Chairperson, we in the ACDP found this an incredibly difficult and complex issue to deal with, given the hundreds of submissions that were opposing this bill. And let us remember, when this act was passed, we were all in agreement that consensual sex between adolescents should be criminalized. We now appreciate that the Constitutional Court has struck it down and that we as Parliament are bound by that. But it is important to note that the court made it very clear that it is not condoning adolescent consensual sex. It is dealing with an issue of the Constitution. Now, when people made submissions, many people did not appreciate the complexities of this matter, and it came down to an issue of religious sentiments. We from the ACDP want to make it very clear that we believe it is morally wrong and not in the best interest of children to engage in adolescent sex. And I'm sure everyone here will agree with that. But the reality is that it is happening. The issue is then how to best address this, and whether by criminalizing this conduct, the risks associated will be alleviated. We thought when the Act was passed that we would address the risks by doing this. But the court said on the evidence before it, the criminal sanction did not deter children or address the risks of adolescent sexual behavior. Now, clearly, the solution is needed to be alternative. We need societal interest. We need families to be empowered. We need churches and other faith-based institutions to be involved. We need schools. We need education, as the chairperson of the Justice Portfolio Committee pointed out. Society as a whole needs to play a far greater role in this whole issue. And we need to educate children about abstinence and the risks of engaging in premature sexual activities. This was highlighted by the court. Clearly, the state should only come in as a last resort where necessary. And we from the ACDP side asked and argued that social development intervention may be a way forward as a mechanism where you have a promiscuous child, a child who then may be in need of care in terms of the Children's Act. It's very clear that the age of consent is 16 years of age, and no adult can have sex with a child, and that must remain. But let us just look at one issue, and that is about children giving consent. Are they able to give consent? Adolescents of similar biological age may differ substantially in their maturity levels. Can sexual conduct between minors be equal? You might have additional issues relating to peer pressure, bullying at schools, narcotics and other stimulants. And then you have a quagmire of potential circumstances that could lead to wholesale sexual oppression of many children. Can a child give consent? And that is why we from the ACDPs suggested that we add in a clause about consent to the effect that a child who is not sufficiently mature and does not have the mental capacity to understand the nature of or risks associated with an act of penetration cannot be seen to give consent. And we're grateful that the committee looked at that very seriously, and that is an issue that we will look at possibly in a committee bill. The last issue is, what message are we sending out? We are not sending a message out that it is now okay for adolescents to engage in sex. And we're also grateful that the preamble was amended to include a warning, as set out in the Constitutional Court, that there is an inherent risk for adolescents of engaging in sex. I thank you.
Thank you, Honourable Member.